Hello members, welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. And today we are diving into the principles of Law of Contract 1, where we shall see the meaning of a contract, and we are hosting a legal genius. He's called Polo Tuli now, one of the sui generis of his generation at law school, and he's going to take us through the basics about the meaning of a contract. I hope you enjoy the content. It's still Agora Legis with Council Ben. Like, subscribe, and share. And that's the only way we can support the initiative, and let's enjoy the content. Well, Council, it's really a pleasure to have you at Agora Legis.
Thank you so much for the invitation. I'd also love to thank our subscribers for this channel. For you subscribing, it's a very good thing, and also it helps you to also appreciate these legal principles on a personal level, and also you can use these principles to prepare for your examinations, but also advise you to appreciate the law itself. We are just here to guide you on the basic principles of contract law 1. Thank you so much.
Exactly, and as earlier said, we are going to look today at contract law 1 and introducing the meaning of a contract. What is a contract? The different elements of the contract, and defining the contract with authority, and looking for the provisions in the law for these different elements of the contract. And without further indulgence, I think Council is going to take us through the meaning of a contract and define a contract.
Thank you so much, Council, for that wonderful presentation about what a contract is. So basically, what a person is supposed to know when we talk about a contract. You just need to understand that a contract has several elements. All of them have to be satisfied for it to be considered a valid contract. In the eyes of the law, there are certain agreements that may not amount to a contract. Exactly. So basically, we as lawyers, we need to appreciate these principles and know what is that which amounts to a contract. And so for us to distinguish what amounts to a contract and what doesn't amount to a contract, we have to look through the elements of a valid contract.
Exactly.
So in the elements of a valid contract, we have agreement, we have capacity to contract, we have the free consent, the lawful consideration, the lawful object, and the intention to create legal relations, to be bound by that agreement. Maybe Council, what someone is supposed to also know is that a contract can either be written or done orally, but then the Contract Act also provides for where it's supposed to be put in writing, where it exceeds, there is a certain currency points, it's about 500,000 Ugandan shillings, the approximate of those currency points, that if it exceeds such an amount of money, the contract must be put in writing for it to be recognized under the law. Mm-hmm. So basically, that is what, just a brief introduction for the layman. But for purposes of the law itself, let us appreciate Section 9 of the Contracts Act. That is Cap 284. It provides for the definition of a contract. A contract is defined under Section 9 as an agreement between parties with the free consent of parties with capacity to contract for a lawful consideration and lawful object, with intention to create legal bound, or just to create those legal relations whereby they can easily be effected in courts of law for them to be implemented. If one party fails to execute their duty, you can sue them in court under civil case, and you would get maybe damages if they have breached their obligation. Regards to that, regards to their obligations in that contract.
Exactly. So Council, tell us, does it mean that if one of these elements that you just listed as to the definition according to Section 9 of the Contract Act Cap 284, does it mean that if in absentia of any of those elements, the contract becomes a light contract, or what is the effect?
Yes, thank you so much, Council, for that wonderful question. What you are supposed to know is that when those one of those elements is missing, even if there are only two, as long as one of those elements is missing, that cannot be considered a contract. In fact, that's where we have the types where we look at those that are recognized by the law and those that are not recognized by the law. We have the void contracts. Those ones are not recognized by the law. Those are the ones which do not meet the specific prerequisites of a valid contract. Exactly. If any of them is missing, we render that contract as never existed from its onset. It's from void ab initio.
Ab initio, exactly.
Yeah. So basically, and you can also see in the case of Balfour versus Balfour, whereby the husband had agreed to be giving the wife some maintenance fees for a specific period of time, and after which he failed to fulfill his obligation in regards to maintaining the wife. So after some time, the wife sued claiming for damages because the man was not fulfilling his duties in the agreement they had.
Promised, yeah.
Yes. So the courts did not consider that as a valid contract, and they mainly just considered it as just a social agreement between family members. It did not amount to a contract. So what our viewers are supposed to know, that all these elements we've talked about, these elements, in fact, they are extracted from the definition of what a contract is.
Yeah.
So if there is no agreement, there is no free consent of the parties. In other words, if there is inducement by either fraud, misrepresentation, or any other form of coercion or undue influence, such a contract is rendered void ab initio, because you've not got the consent of that particular person in the right way. You've coerced him maybe through intoxication or something like that. So such arrangements do not amount to a contract where there is coercion by any of those factors. In fact, in contract law too, they are called vitiating factors.
Exactly.
Thank you so much.
Dear viewers and listeners and members of the Agora Legis community, we have now known that we have now seen the definition of a contract and known that if one of these elements is missing, we cannot talk about a valid contract. And he has talked about voidability of the contract, to see that if one of these elements is missing, the contract does not meet the requirement of being called a contract. If the agreement does not meet the requirement, it cannot be called a contract, and that's how we see that it's going to be void ab initio. So counsel, after this, can you now list for us these elements one by one and tell us how it applies and maybe the legal provisions in the law and how they apply?
Thank you so much, counsel. So like I've told you, from the definition is where we get the elements. So I'm going to begin with element 1, which is agreement. So what do we mean when we say an agreement? That these two people sit down and they agree on particular things. For example, on particular terms of their contract or arrangement.
Exactly.
It'll be like, I'm having my phone, I have maybe my Techno Spark 2, and I'm selling it to you, and you agree to it that I'm going to give you, I'm having my Techno Spark 2 that I want to sell to you at 200,000 shillings, 200,000 shillings, 200,000 Ugandan shillings. If you accept, we take it that we already have that agreement. That
exactly.
We have an agreement. In other words, we have what we can call the meeting of minds.
Yeah.
Yeah. Basically, that's the consensus item. Where it is established, we take it that element 1 of a valid contract is satisfied, where there is agreement, the meeting of minds. As long as you've agreed to the terms of my offer, that means that already we have established element 1, which is the agreement. Thank you. So that is for element 1. And also we can also talk about the free consent. Free consent of the parties. It is very pertinent, a very pertinent issue. I've already talked about it. That if it is realized that the consent, you've got consent from me through maybe fraud or coercion, undue influence, or any other, all those vitiating factors, misrepresentation, mention them. All, if consent is obtained through such means, such a contract can be rendered void or voidable depending on the circumstances of the case.
It's provided under Section 12 of the Contract Act.
Yeah, Section 12 of the Contract Act. Maybe our viewers or listeners must know that the old Contracts Act was removed and we have a new one. We have the current law is Contracts Act Cap 284. The old one was of 2010, but the apparent one that we are using is Contract 84, Cap 284. It's a very important thing because if you're citing wrong laws,
outdated law,
yeah.
The point is void also.
Remember, counsel, that you say that a good lawyer is one who knows where to find law.
Exactly.
So basically, our listeners, our viewers can appreciate those principles. Can also try Professor Ben's book, Contract Law, breaks down all those different topics very, very well. So that is for reference. Those books, we have to share them with our listeners and viewers.
Exactly.
So we've talked about the free consent. We've also talked about agreement. Counsel, allow me to move to consideration.
Exactly.
Consideration. Basically, what do you understand by consideration? Consideration basically means that there must be a party that is receiving something and there must be a party that is losing something. For example, let me go back to the scenario just given you of the phone, the Techno Spark 2. That I'm giving you the phone. I'm giving you the phone, and for you are giving me back the 200,000. So this exchange is what we call the consideration. Meaning I have to lose something, which is my phone, then you give me something in return, which is the money. So what, in the eyes of law, it must be a valuable consideration. Meaning, if I'm just doing charity or giving you things freely, something like that, that cannot amount to a valuable consideration. If because I'm just giving you, I'm donating to you, so that cannot amount to a valid element of that contract.
Exactly.
So maybe another thing that council people are supposed to appreciate further on this topic is that the consideration must be lawful. It must be recognized by the eyes of law. If I do something for you and then maybe we put a contract and we're like, you help me go and kill James, I'm going to give you 5 million Ugandan shillings. Even if you go and kill James and I fail to satisfy that consideration and give you that pay, you cannot enforce that in courts of law. In other words, if you even take yourself there, they may prosecute you under criminal law.
Exactly.
So basically, you need to know that the consideration must be valuable, yes, and lawful. Yes, there must be that. So basically, we've now discussed 3 elements of.
By the way, I think the lawfulness of consideration is provided for under Section 18 of the Contract Act.
Yeah.
Yes.
Thank you so much for that.
Counsel.
For that provision of the law. So we also have the intention to create legal relations or to be legally bound by the contract. Yes. So what do I mean by this? You see, what distinguishes this a contract from any other document or any other arrangement or agreement is that for it has legal implications. If you breach or you fail to fulfill your obligations in regards to that contract, you can be sued for damages. You understand what I'm talking about, counsel? So let me give you an example of the other case of Khalil versus Kabolik Smoke Ball. A very important case discussing that. So that that company that was making smoke balls placed an advert talking about their products, which were the smoke balls, that whoever took those smoke balls and contracted influenza would be given £100. £100, yes, as to fulfill what they had talked about in that advert. Yeah, in that advert. So one of the people who got to get that advert and know about it, bought those smoke balls, Mrs. Khalil, and then used them, and then after using them or consuming them, she was able to contract the influenza. So she sued the Kabolik Smoke Ball company for the £100. And also, when this advert was being made, I'd forgotten to tell our viewers that to show their seriousness in this issue, the Smoke Ball company deposited £1,000 with Alliance Bank to show their seriousness in the matter. So when they reached the court and Khalid was claiming for the £100. The defense team, of course, which is the company at hand, the smokeball company, was denying that there was no contract. In other words, they even say that what they did could not amount to an offer because it was not made to any specific party, and if it was, even if they did not get to know about the acceptance by Mrs. Khalil. And the courts did not buy that because they were like, this person had the company had put that £1,000 and registered it with, and deposited it in the bank. That was to show their seriousness in the case or in the issue. So they were willing to pay that amount of money to anyone who contracted. So Mrs. Khalil buying those smoke balls, she fulfilled her part of the contract. So if she got when she got the influenza, she was supposed to be compensated the £100 that smokeball company had promised to pay. So they quashed. They were able to give her that amount of money because they found that an offer could be made even to a whole world, can be made to very many people. Any person who accepts it is willing. Any person who accepts it must be given any remuneration or any reward that's supposed to be, as long as it was part of that advert. So they could not consider it as a mere trade path.
Exactly.
Yes.
So as long as there is establishment of an intention to be legally bound,
yes,
we can talk about a contract.
Yeah, and it is enforceable in courts of law, as you've seen in that case, and also in Professor Ben's book, Contract Law. There is an example where he gives, and it's like people who are making those adverts, they should be very critical in their wording because it can affect them. Like you are seeing in this case, they did not know that would be enforceable, but the courts interpreted it, and they were like, this person deserves the £100 because he fulfilled his obligation in regards to that contract. She fulfilled the acceptance, so they were supposed to compensate her. Then in Professor Ben's book, they are saying that if a company making, let's say, mattresses comes and says that everyone that will buy a mattress within this season, maybe from May to June, will be given, let's say, a jerrycan of cooking oil. And then all of a sudden 3,000 people buy those mattresses. The company cannot come claim later that, you know what, we only had 300 jerrycans of cooking oil. You have to compensate all those ones because you are bound by what you say. Yes. So if it is clear and you are supposed to be bound by what you've put in that advert, that means you have to follow it. If you fail to fulfill your part of the obligation of the offer, the other party can sue you in courts of law and can succeed. Then he said that where such a company wants to avoid itself from liability, it can be very clear in the advert, and then it says that
put a disclaimer.
It can put a disclaimer, or it can just restrict the amount of people it would give those jerrycans. Instead of saying everyone who will buy a mattress within this season or this one will be given a jerrycan of cooking oil, it can say we are going to give the first 100 buyers of our mattresses, we'll give them each one will receive a jerrycan of cooking oil. So for the companies to be protected under the law, they must be very clear and put the wording must be clear such that it does not extend a lot of liability onto them. Exactly. Thank you so much, Council.
Yeah. The last element remaining is just what we call capacity to contract, and Council is going to take us to capacity to contract provided for under Section 10 and tell us what makes someone able to contract or to embark upon legal relationship and contractual duties.
Thank you so much. So capacity to contract is also a very key and important aspect of an element of a valid contract. Why? We need to ascertain the age of that particular person that is held into a contract. You get? So we find that the Contracts Act in section 10 counsel, it provides for capacity to contract. In the eyes of law, who has the capacity to contract? Someone who has attained the age of 18 years and above, someone who is mentally okay, is mentally stable, and is able to understand the terms of that valid contract. So even in Section 11 of the Contracts Act, Cap 284, it further talks about who is the person who is mentally stable to understand the elements of that contract, or to understand the implications of that contract. The reason as to why we are emphasizing this part is that we don't want someone to be held liable for failing to fulfill his side of the or his duty in regards to that contract, and then he comes out saying, I was not understanding what was meant by these terms of this contract. That's why we say that for any person who is maybe going in a land transaction or any form of contract, he must read that document and understand the terms of that very contract. Otherwise, it may have negative implications for that person if he fails to fulfill his duty in regards to that contract. Maybe counsel, what I've forgotten to talk about is that one I've talked about is the capacity to contract. It's very important for us to appreciate that. Then I also talk about the acceptance. You must accept. How do you show your acceptance? It is through the terms of that contract. If the contract says for people that are applying to this organization and they want to be given the jobs, they must maybe send their application through our emails. If they use any other means, of course I am at liberty to refuse to give these people their jobs, to give them jobs in case they did not follow the terms of my contract. If I've said you use the post office, why should you use anything which is contradicting to that? Because by the time I tell you let us use the business email, I am very sure that that's where our point of reference will be. So you cannot come back later to say you qualify maybe for the job, but you are not called for the interviews or something like that. We've specified. So you must know that acceptance, you must accept. Acceptance can either be by conduct or through, of course, through writing, or because by the time you, for example, in that case that I've talked about of Khalil, you see that Khalil accepted, and her acceptance was by conduct of buying the smoke balls. And when she contracted the influenza, she was able to claim for her £100. Yeah, so basically, what our viewers should know is that all those elements that we've talked about, the free consent, capacity to contract, the agreement, lawful consideration, lawful object. By the way, we talked about lawful consideration and we forgot to talk about lawful object. Even the object itself or the subject matter of the contract must be lawful. For example, in this country, they don't allow selling of these narcotic drugs. They are not allowed by the law. So if you are selling such a contract, if you are having a contract where people are selling such substances and you fail to get paid, you cannot enforce it in the court of law. It cannot be enforced in the courts of law. They will say that contract will be considered void ab initio. In other words, like as if it has never existed in the eyes of law. Thank you so much, counsel.
It's really a pleasure to have you again at Agora Legis. We are really grateful, and members out there, I hope you have enjoyed the content. We are promising now to make videos for each and every element of the contract where we break down the principles, and I think we shall call him back. He's Tulinao Apollo, and for purposes of the channel, thank you for watching. It's Agora Legis with Counsel Ben. Please like, subscribe and share, comment. We really like the feedback. Tell us where you didn't understand, tell us where there's something missing, where you feel like you're not satisfied, and we are really grateful to help. Our main purpose is to promote academic excellence. We Agora, we are Legis, the platform of legal minds. Thank you for watching.